webinar on the theme and series theme on contemporary reflections on international law, on the specific theme, international judicial process during COVID-19. I have with me a very distinguished set of jurists, but before we formally welcome all of them, I would like to extend a warm welcome to His Excellency Mr. Venu Rajamani, the Ambassador of India to the Netherlands. This webinar is jointly hosted by Judicial Global Law School of OP Jindal Global University and the Embassy of India at The Hague. Ambassador Rajamani, over to you.
Thank you, Dr. Rajkumar. Judge Abdul Kavi Yusuf Yusuf, Honorable President of the International Court of Justice, Judge Dalveer Bhandari, Judge of the International Court of Justice, Registrar Philip Gautier from the International Court of Justice, and Dr. C. Rajkumar, my good friend and founding Vice Chancellor of the OP Jindal Global University. A warm welcome to all of you for participating in this webinar, and equally a very special welcome to all participants who are viewing this program online. Friends, this webinar is part of a series called Contemporary Reflections on International Law, which the Embassy of India in The Hague, along with the OP Jindal Global University, is bringing to the people of India as well as viewers all over the world. This series is primarily meant to bring the best of legal minds, their wisdom, to India, to the lawyers, to the students, to the faculty, and to all people interested in international law. While the pandemic constrains and limits us in many ways, it also liberates us in some ways. And one of those is a webinar of this nature, where we are able to bring President of the International Court, Judge Yusuf from Paris, which is where he is today, Judge Bhandari from Delhi, Mr. Gautier from The Hague, all together for a discussion on the title of today's webinar is International Judicial Process During the COVID-19 Pandemic. How has the pandemic affected the international judicial process? People in India are familiar with how the courts in India have been struggling to adapt themselves to this crisis and to find new ways in which they can continue to deliver justice. But equally today, we will hear from these very eminent persons that we have with us, how the International Court of Justice has been coping up with this crisis. Let me mention that this is the second webinar in the series that we have commenced. The first webinar discussed the contribution of Indian judges on the International Court of Justice since the court was formed. Judge Bhandari is in fact the fourth Indian judge on the International Court of Justice. And the next webinar is going to be on the theme of practice before international arbitration tribunals, and this webinar will be held on October 28th, and it will feature the Secretary General of the Permanent Court of Arbitration, Mr. Hugo Siblis, as well as Dr. P.S. Rao, a leading international legal luminary from India. Friends, let me briefly introduce Judge Abdul Kavi Ahmed Yusuf to you. I would begin by saying he is a great friend of India. He has had long association with people from India who are involved in the field of international law. He has visited India many times. He has had an association with the Afro-Asian Legal Consultative Committee, which has its headquarters in Delhi. Judge Yusuf became a member of the court in February 2009 and has been president since February 2018. He was previously judge ad hoc in the ICJ in many cases. He has served in many high positions within the UNESCO, the UNIDO, and the UNCTAD. He has been an arbitrator as well as a presiding arbitrator in many cases. He is founder and general editor of the African Yearbook of International Law. He has a doctorate in international law from the Graduate Institute of International and Development Studies in Geneva, and also a doctorate in jurisprudence from the Somali National University. President Yusuf has honorary degrees from a number of other universities, and he has a large number of publications and books to his credit. I go on to Judge Bandari, whom many of you in India would know well. As I mentioned, he is the fourth Indian to sit on the bench of the International Court of Justice. He has been on the bench since April 2012, and he was re-elected in February 2018, an election which caught the attention of the media across the world, and in particular in India. So many of you would have read the political context in which that election was held and how he came out as a big winner, along with India as the nominating country. Judge Bandari was a judge of the Supreme Court of India. He was Chief Justice of the Bombay High Court and a judge of the Delhi High Court. In 2014, the President of India conferred upon him the Padma Bhushan, which is the third highest civilian award in India. He has made immense contribution to law and justice in India as well as across the world. He also holds a number of honorary degrees from several universities. Mr. Philip Gautier, the Registrar of the International Court of Justice, is the third panelist who will speak today. Mr. Gautier has been registrar since May 2019. Prior to coming to the International Court of Justice, he was registrar of the International Tribunal for the Law of the Sea from 2001 to 2019. And prior to that, he had a long innings within the International Tribunal for the Law of the Sea. He has very closely worked with Dr. P.C. Rao, former Indian judge at the ITLAS, and they have together authored a book. Mr. Gautier was member and head of the Belgian delegation in negotiations relating to the law of the sea, as well as on many other important issues. He holds 2 degrees of Masters of Law, a Master of Philosophy, and a Doctor of Laws from the Catholic University of Louvain. He has written on diverse topics of international law in journals of repute, as well as in books. Finally, our moderator for this evening, Dr. C. Rajkumar, the founding Vice Chancellor of O.P. Jindal Global University. He is also the Dean of the Law School and a very eminent legal personality, legal expert. Professor Dr. Rajkumar has degrees from all the eminent universities that you can find in the world, from Harvard, from Oxford. He has a degree from University of Hong Kong, from Delhi University, and his initial education was in the Loyola College. And it is to his credit that O.P. Jindal Global University is a world-class private university today. It has many distinctions in its name. It is one amongst 10 institutions in India chosen as the most eminent, as institutions of national eminence. It is the only private university ranked amongst the top 150 universities in the world. It figures in the QS Young Universities rankings of 2021. And its law school is ranked #1 in India. It has been nominated as having the best liberal arts school in India. It is the #1 private university in India, something I mentioned, and it is amongst the top 700 universities globally. So I conclude my opening remarks stating that I personally am greatly looking forward to this discussion, and I'm sure the entire audience is. Judge Yusuf, thank you so much for joining us this evening. Similarly, Judge Bandari and Registrar Gautier. Let me say that as an outsider who has seen many judgments being delivered in the International Court of Justice, as a person who has participated in many of the arguments before the court as a member of the Indian delegation, it has often struck me that the International Court of Justice is an extremely formal institution where essentially lawyers come and state their piece and then the final judgment is read out. The real debate, discussion, deliberations all happen behind the door amongst the judges rather than out there in public. And sometimes you wonder if couldn't there be at least space and provision for a question and answer session? Wouldn't it be nice if the judges could ask questions to the lawyers could argue, if not argue amongst themselves, at least have some kind of a to and fro between the judges and the lawyers and their teams before the court. But so far, the court has not proceeded to that level, I understand, because of problems in translation, because of time constraints, constraints involved, and a variety of reasons. But when you compare that with how quickly the International Court of Justice has adapted to technology and how it has ensured that the pandemic did not shut it down, and even if it was closed for a little while, how quickly it came back, and using the latest of technology, it has enabled judges sitting in various parts of the world look at the cases which have come before it, deliberate on it, and even deliver judgments. It is truly amazing. I give my compliments to you. I pay tributes to the International Court of Justice, the judges there, the registrar, and its entire team for having been so dynamic and so efficient in ensuring that the cause of justice never suffers. Thank you very much. I thank you on behalf of India, and I thank you on behalf of the entire international community for the wonderful service that you are rendering. Thank you very much. Over to you, Dr. Rajkumar.
Thank you very much, Ambassador Rajamani, for that wonderful introduction. Of course, I would like to take this quick moment to introduce Ambassador Rajamani himself. He has been a career diplomat for over 3 decades with a very wide experience. He's also the permanent representative of India to the Organization for the Prohibition of Chemical Weapons in The Hague, as well as responsible for India's relations with the International Court of Justice and the Permanent Court of Arbitration. Ambassador Rajamani appeared on behalf of India before the ICJ in the matter of advisory opinion concerning the legal consequences of the separation of Chagos Archipelago from Mauritius. He was also a member of the Indian delegation before the ICJ in the Jadhav case and co-agent of India in the case concerning the Enrica Lexi incident, which is the Italy versus India case before the PCA. Prior to his present assignment, Ambassador Rajamani held the prestigious office of the Press Secretary to the President of India during tenure of President Pranab Mukherjee from 2012 to 2017. Ambassador Rajamani holds degrees in law from the Mahatma Gandhi University in Kerala and a master's degree in international relations from the Jawaharlal Nehru University. Since they've already been introduced, our distinguished guests, let me move to the subject matter of today's absolutely critical panel and webinar that we are hosting. I am grateful to the Indian Embassy at The Hague and also our distinguished guests for accepting our invitation to be part of this webinar on the theme International Judicial Process during the COVID-19 pandemic. Now, capturing the public idiosyncrasies during a pestilence, French philosopher Albert Camus wrote in his novel The Plague, and I quote, "In short, we return to our prison house. We had nothing left us from the past, and even if some were tempted to live in the future, they had speedily to abandon the idea. Anyhow, as soon as could be, once they felt the wounds that the imagination inflicts on those who yield themselves to it. Thus, each of us had to be content to live only for the day, alone under the vast indifference of the sky," unquote. In the same vein, there is no aspect of human thought that has not been stricken by the above said attitude, as there is no aspect of human life that has not been affected by the COVID-19 pandemic. However, with our remarkable capacity of resilience, we are situating ourselves against the trials and tribulations of the ongoing pandemic, making the immediate present our own. We are indeed creating a new imagination. At a time when COVID-19 was spreading irrepressibly to become a pandemic, many development agencies such as the UNDP expressed their concern that the destabilization of the economy due to the loss of normalcy might lead to a grave miscarriage of justice. Hence, this is a time when extreme quote-unquote judicial oversight is needed. A guidance note entitled Ensuring Access to Justice in the Context of COVID-19, issued by the United Nations Office on Drugs and Crime, stated that, and I quote, "As states around the world adopt emergency measures to address the crisis, they must continue to uphold the rule of law, protect and respect international human rights standards and basic principles of legality and the rights to access justice and due process," unquote. Fortunately, the judiciary did not disappoint. Out of their deep-seated commitment to the ideals of rule of law and access to justice, judicial systems around the world were quick to respond to the crisis with a sense of responsibility, agility, and openness. Indeed, in India, the Supreme Court of India and the high courts across India have also responded. In fact, in a recent press release, the International Court of Justice assured the international community that, and I quote, in spite of the current circumstances, it will continue to discharge its judicial functions and to deal with matters newly submitted to it or already pending before it, unquote. Today, not only is the world faced with a broader demand for justice, but also with the challenges of operationalizing justice in times of a worldwide lockdown. As social distancing becomes the norm and new way of living, courtrooms across the world have had to undergo an overnight digital transformation. There has been a complete reimagination of the judicial process, from revising the priority order for filing cases to appearance of lawyers before the courts to exemption from the dress code for lawyers. From the mundane to the sublime to the profound, a complete reimagination is taking place. The COVID-19 pandemic is indeed going to be a redefining moment for legal professionals to innovate, to not just cater to the considerable strain on the legal system, but also to embrace technology to expedite the delivery of justice. Our world just became more VUCA, volatile, uncertain, complex, and ambiguous than ever before, posing questions on the role and the future of international law in the age of COVID-19. Hence, it is in this backdrop of these challenges, responses, and adaptations that the current webinar is hosted. I am grateful to Honorable Judge Abdul Qawi Ahmad Yusuf, the President of the International Court of Justice, Honorable Judge Dalveer Bhandari, Judge of the International Court of Justice, and Honorable Registrar Philip Gautier, Registrar of the International Court of Justice, for accepting our invitation to be in today's webinar. Let me begin my first question to the President of the International Court of Justice. COVID-19 is a time when states act as if under an emergency, many times under its primary responsibility to safeguard the well-being of its citizens, which is often the constitutional guarantee to its people. States end up breaching many international obligations in force, invoking state responsibility under international law. If an advisory opinion were to be sought from the court, would the court consider action by states during the COVID-19 pandemic as falling under the exceptions of force majeure? Or arguably, are these type of situations are part of the larger imagination of the ICJ when it comes to dealing with this? I totally understand if you won't be able to answer a hypothetical of this kind. President Yusuf.
Professor Rajkumar, and I also thank Ambassador Rajamoni. And I thank both of you for organizing this webinar and for giving us also an opportunity to explain to a wider public what the court had done and had to do in the face of COVID-19. And you know that our statute will be 100 years old this December. And it was written and prepared by a committee of jurists appointed by the League of Nations, the Council of the League of Nations. And that committee of jurists met in The Hague to prepare the first draft of the statute from June 1920 to July 1920, exactly from 16 June 1920 to 24 July 1920. And that was about 2 to 3 months after the end of the Spanish flu. And the Spanish flu, which started in Europe, they say it started actually in the US, but then afterwards it came to Europe, and it was called the Spanish flu because a lot of publicity was given to it in Spain before any publicity was given to it in the rest of the world. It is estimated that it must have killed about 50 million people. And it was immediately after the end of the flu that the Committee of Jurists were able to meet in The Hague. And of course, they could not imagine working remotely together and drafting a statute of the court by video link or by video conference. And they could have never imagined it, that if it was not possible to meet in person, that there would be any other way of working together, either as a committee or as a court. And you see, 100 years later, we are able to react and react very fast to the surprise, which of course was the COVID-19 to all of us in March 2020. We were able to react very fast and to put in place the necessary measures and the necessary mechanisms for the court not to miss a beat. And I can assure you, we did not miss a beat. We were able to continue our work, and we were able to continue fulfilling the mission that was entrusted to the International Court of Justice by the international community. And by early April, we were already meeting in various committees of the court in order to decide how we should organize our deliberations, our meetings, our hearings, the delivery of judgment is remotely, all of this remotely. And thanks to the foresight of our registry and of our IT staff, the court had already in place the technology to be able to work remotely when we were hit by the COVID-19 in March this year. We already had in place a very well-functioning, very performing system, which would allow us, as part of the United Nations, to communicate with each other wherever we were, and to communicate with other parties of the United Nations system. And this was a system that was conceived for the United Nations some time ago. And it was installed in the court in 2019. So you can see by 2020, when the COVID-19 hit us, of course, by surprise, we were mostly ready. And that is how we were able to catch up quickly and reorganize ourselves. Some people took our initial reactions as suspending our activities. We never suspended our activities. What we said was that we could not hold the hearings that were scheduled in March and April in time. And the reason was very simple. We were trying to organize ourselves and reorganize the hearings as remote hearings. And therefore, we rescheduled those hearings. And therefore, we started holding hearings again a bit later. But of all the cases that were scheduled for hearing in 2020, there was only one case that was moved to 2021. All the other cases have actually been heard in 2020. So that, as an introduction to the answer to your question and to how the court actually had to deal and to react very fast to the COVID-19. And we continue with our judicial work. We continue with our administrative meetings and our deliberations. And we keep working together wherever the judges of the court may be at that moment. Most of us are in The Hague most of the time, and therefore it is very easy for the majority of the members of the court to sit in hearings and to deliver judgments from the Great Hall of Justice, as you may have seen, which has a sense of symbolism for us all. And that is the reason also why we adopted the hybrid form of hearings. We did not want to adopt a virtual hearing. It does not really suit the court, and it's not convenient for the court. The International Court of Justice has a very solemn sitting, has very solemn sittings, and it has a certain symbolism about it. And we did not want that to be lost, even in this, through the use of these technologies. Now, briefly reacting to your question, let me tell you that when advisory opinions are sought from the court, the most important thing is actually the way the question is formulated. And one is the organ which seeks the advisory opinion from the court formulates that question, and that actually takes a long time and goes through a lot of negotiations, whether it is the General Assembly, the Security Council, or those specialized agencies that are allowed to seek advisory opinion from the court. Once the question is formulated, then the court examines and analyzes each word of that question in order to be able to answer it. So when you ask me a hypothetical question of an advisory opinion on the actions of states due to the COVID-19, my very brief answer is, show me a question and let us look at it. I am not the court, of course. I am only one judge of the court. And the judges of the court could give you then their opinion on it. But without a question, without studying how the question is formulated, what the question is all about, we do not answer abstract questions on advisory opinions. That is the short answer.
Thank you very much, President Yusuf, for first of all, really introducing the functioning of the court during these extraordinarily difficult times, but also to recognize the important and solemn role and responsibility of pursuing and advancing the cause of international justice that the ICJ is performing now. I, of course, recognize the fact that hypotheticals of this kind may not be able to be answered, and I was conscious of that, but I wanted to begin the conversation surrounding the extraordinary challenge on the basis of which such issues are being discussed in domestic courts, and to what extent international courts such as ICJ will be responding to. Let me move to Justice Bhandari. Justice Bhandari, there's a book entitled The International Court of Justice and the Effectiveness of International Law by Mr. Philip Pover, the former registrar of ICJ, and in which he writes, and I quote, "The effectiveness of a court is always dependent on its capacity to adapt to the evolving needs and circumstances of the society in which it operates." Unquote. During the unprecedented circumstances as those created by COVID-19, what do you think is the reimagination that is required in terms of the law and procedures of the court, including possibly its registry, in order to fulfill its above said judicial functions, which are instrumental in ensuring the effectiveness of the rule of law? Justice Bhandari.
Thank you, Professor Rajkumar. Thank you and His Excellency Rajamani for organizing this webinar. It has given an opportunity to meet all friends and have discussion with all of you. Year 2020 is a significant year in many ways. This year, United Nations celebrates commemoration of its charter signed 75 years ago in San Francisco. This year, as the President has said, the ICJ celebrates 100 years of its statute in December 2020, which it inherited from its predecessor, the Permanent Court of International Justice. This year, The entire world is facing grave and serious and extraordinary problem of COVID-19 pandemic. The entire world has been shaken. The pandemic has affected every part of the human endeavor of the world. It has badly affected economies of the world, industries, commerce, trade have been badly affected. Some industries like tourism has come to grinding halt. Other industries have been very badly affected, and it's very difficult to say when they will revive. The work of almost all courts in the world was severely affected. Hearings were rescheduled in most places, but ICJ seems to be an exception to the rule, where we virtually had done the same work which we would have done during the regular period, except rescheduling of initial hearing in 2 cases. You would be surprised to know that not only we did the regular court work, we did the administrative committee's work, the rules committee's work during this period. So we were very quick to respond to ensure that the court's backlog does not increase and people all over the world are able to get effective, fair, and timely justice. It has happened because of the dynamic leadership of our president, who took effective measures to ensure that cause of justice does not suffer. With the help of modern technology, necessary arrangements were made. And if I recall it correctly, on April 20th, 2020, we had hybrid deliberation. President and registrar were in the court, and some members were also there, and other members were in different parts of the world. It was a fascinating experience because for the first time in the history of the World Court, this kind of deliberation took place. बंद हो गया.
We can hear you, sir. Go ahead.
You can hear me because
please go ahead. We can hear you.
Your photograph disappeared, so that
No, we can hear you. We can hear you very well.
So with the help of our IT department, we were able to virtually have the same judicial work and administrative work as we were doing normally. Thanks to our IT department for doing excellent job. During this period also, we have amended Article 59.2 and Article 94.2 of the Rules of Committee of the Court. Article 59.2 states that court may decide for health, security, and other compelling reasons to hold a hearing entirely or in part by video link. The parties shall be consulted on the organization of a hearing. So this paragraph was added in Article 59 of the rules. Similarly, we made changes in Article 94.2, which states that the judgment shall be read at a public sitting of the court. The court may decide for health, security, or other compelling reasons, and the judgment shall be read at a sitting of the court accessible to the parties and the public by video link. the court's judgment shall become binding on the parties on the date of the reading. This is an extraordinary achievement which we accomplished during this period. On June 29, 2020, while commemorating 75 years of the UN Charter, our dynamic president, Judge Yusuf, mentioned, and I quote, 75 years later, the court is still spreading the bright rays of sun of justice and the rule of law throughout the world and offering all the states possibility of settling dispute peacefully through law instead of resorting to brutal force. On June 30th, 2020, for the first time, court had a regular court hearing, partially via video conferencing, in the case concerning arbitral award of 3rd October 1898 between Guyana and Venezuela. Now, this was an extraordinary achievement of the court. That entire court hearing took place by video link, and we were in various parts of the world. I attended the hearing while sitting in Delhi. It's heartening to see that the World Court has sent a strong message to all courts, other judicial tribunal and institutions, that even this pandemic cannot hamper the commitment of the court to ensure compliance of international rule of law. In maintaining international rule of law, involvement of contribution of other stakeholders is equally vital. And we are grateful to other stakeholders who cooperated with the ICJ so that we could have the hearing of these matters. We hope to resume physical hearing and earnestly wish the normalcy to resume all over the world. Meanwhile, the court is fully equipped and committed to ensure compliance of international rule of law. Thank you.
Thank you very much, Justice Bhandari, for taking us through the evolution of some of the way by which the court has responded during this crisis. It is only a demonstrative of the fact that the commitment and dedication to the cause of justice among the judges individually, but also ICJ as an institution, augurs well for the kind of faith and trust that the international community has deposed on these institutions. Now, let me move to Mr. Gautier. Mr. Gautier, one of the major challenges that the court judicial institutions in general are facing is their responsiveness to reimagine the judicial process. Now, while this COVID-19 crisis has caused a rearrangement of priorities and even at times postponements at the domestic level, it has also caused substantial judicial delays in which parties have found alternative means of dispute resolution effective and speedy even during the pandemic, thanks to its informality and liberal approach of ADR. Now, of course, we are conscious of the fact that such aspects of how commercial disputes get resolved may not be applicable in the same manner in the way ICJ functions. Now, do you see a trend in the near future of international courts and tribunals using provisions in their founding statutes of good officers, arbitration, and mediation? These things, would they end up playing a role? Could negotiation be part of the process which institutions such as the ICJ can adopt for some of its disputes?
Thank you, Professor Rajkumar, and I wish also to take this opportunity to thank Ambassador Rajamoni. It's a very good initiative to organize and to bring us to India. in order to answer those questions. It shows the dynamism which can be generated even despite a crisis like the one we know we experience. And it shows also that even if we are faced with difficult situation, we may innovate. And what you have put into place, I think, reflects also the approach of the court. And I wish to really to pay tribute to the dynamism of the court, and in particular of its president, and also the dynamism of the colleagues from the registry. There is a team, and it's important to work as a team when you have to face such rough water, uncharted water. To answer your question, I think, there are different means to settle disputes. They may be diplomatic or judicial, and that's reflected in Article 33 of the UN Charter. But I think there is a basic distinction between those diplomatic ways and means and the role of a court, which is to render justice through normally binding decisions, but there is also an advisory function in the case of the court. I would say negotiations and other diplomatic means will remain. But what has been explained also is that given the uncertainties and the problems we may experience in the future, there is a further need to have a robust mechanism for the settlement of dispute, and that is offered by the court. And as the president mentioned, actually, there were sometimes references made to the stop. The court would have stopped its functioning, but it has been explained by the president that it was never the case. There is no reason for parties, for member states, for states, not to bring a case before the court, because on the contrary, the court took action in order to deal with the cases in front of it. And even if there were some postponements, that was explained, all those cases have been, the oral proceedings took place with respect to those cases, except one, but that was at the request of one of the party, and it was to a certain extent not opposed by the other party. There was a valid case on the basis of COVID-19 to postpone. I want to be very clear that the role of a judicial institution is to a certain extent reinforced in such a period of time. And the International Court of Justice has shown that it is able to react, to adjust. And therefore, the only remaining question, and to conclude, my answer would be really access to justice. Because due to this current crisis, there may be cases which should have been brought to the court, which are not brought because of financial reasons or because states have other priorities. And it's very important to show to the international community, to the members, that the court can still function efficiently and that there is no reason to postpone bringing cases because that would just be a delay in the solution being brought through a judicial decision. Just that, in a nutshell, what I wanted to say.
Thank you very much, Mr. Courtier. Let me move to the next segment of what we are discussing. We are, by the way, live on Facebook and YouTube for all those viewers. We are live on Facebook and YouTube for all those viewers who are watching this program. Please send in your questions, and I hope to ask some of those questions to our distinguished jurists who are part of this webinar. President Youssef, one of the things that a large part of the people who are interested in the functioning of the court is keen to know is about the response to the COVID-19 pandemic. As you mentioned briefly, there was a series of press releases by the court emphasizing on the need for the continuance of the judicial process. However, the decision to continue the functioning of the court came after the initial decision to suspend all hearings. Now, this, of course, demonstrates something quite extraordinary about the need for reopening in the interest of the sustenance of the rule of law. Can this be seen as a part of a larger commitment to rule of law and justice that the court is demonstrating? And an equally important question that has come about is that just as we talk in terms of the healthcare system, which is considered as an essential service, should justice delivery systems be recognized as an essential service even during a COVID-19 pandemic?
The delivery of justice, I think, is more than essential even during the COVID-19, because unless you have justice, even at the international level, and actually more so at the international level, you may have all kinds of tensions, you may have all kinds of misunderstandings, you may have all kinds of disputes, which continue festering among nations, and therefore peace among nations may be undermined, and we don't want peace among nations to be undermined. And that is why I say that we did not miss a beat and that we reacted very fast to the COVID-19. And let me add the following. You said that some hearings were suspended. No hearings were suspended, they were just rescheduled. And the reason why they were rescheduled is very simple. You know, in order to change our methods of work and to change also some of our rules, although it was not necessary to change the rules, but we did not want any misunderstanding. And therefore, we did not want people to come and argue, oh, but what did the court, how did the court just shift to hearings, hybrid hearings, and to the delivery of judgments in hybrid sittings, etc. What does its statute say about that? What do the rules say about that? We did not want this kind of speculation, but there was actually no pressing need to formally change our rules, the rules of procedure of the court. But we thought that to avoid misunderstandings, we would further clarify our rules. And we would say that in case of need, for health reasons or for security reasons or for other reasons, the court can actually hold hearings or deliver judgments in a hybrid format. As I said before, we did not want to move to a totally virtual format. That does not fit with the solemnity of the court and with the International Court of Justice. And therefore, we have the majority of our judges sitting in the Great Hall of Justice, and the other judges joining in and consider it to be participating equally, either in the hearing or in the delivery of the judgment. And in order to bring all of that on board in a very short period of time, not only did we have to use and find, to identify and use the necessary technologies, but we also had to elaborate two protocols, internal protocols, and one actually an external protocol. And it was very important, you know, to embark on the elaboration of those protocols, because when you change your methods of work, and when you want to work remotely through these technologies, you need all the members of the court and the staff of the registry who are assisting and the supporting the court to. We have lost Professor Rajkumar. I hope that he will join us. Yes, now you are back. You want them to actually observe a certain rules. And that is why the internal protocol was intended to assist the members of the court judges ad hoc who are not members of the court, but who join us for a specific case. And the registry, how each one of them would actually conduct himself or herself properly in a remote meeting, on a remote hearing of the court, how they would connect with the other members of the court and connect to hearings, and how these hearings or meetings will be conducted. So we adopted an elaborate protocol for our internal meetings. And then we adopted another protocol for hearings. And there we established guidelines for the parties so that they would know how to conduct themselves before the court, because they knew, for example, what to wear before the International Court of Justice in an in-person hearing. But what would they wear when they are addressing the court remotely? Would they appear, as you see sometimes in webinars, people wearing jogging suits and addressing other people from their kitchen, you know? Would counsel agents be allowed to appear before the International Court of Justice like that? No, absolutely not. You know, so you had to establish certain rules and certain ways of conducting themselves also for the parties, for their agents, for their counsel when appearing before the court. And that is why we thought that we cannot just have the same hearing that was scheduled at the end of March. We could not have it remotely at the end of March. We moved it to the end of June. And that is the one that Judge Dalvir Bandari just mentioned, because we moved it to June. And then the other hearings that were scheduled for June and July, we moved them to the end of August and September. And so now we have had hearings in June, we have had hearings at the end of August, we have had hearings at the end of September. And the only reason we are not having hearings now in October and November is because the triennial change of the composition of the court will take place in February 2021. And that requires us to finish all the cases that we have heard. And therefore, since it normally takes us about 4 to 6 months to finalize a case that we have heard, during those periods in which the composition of the court is to change, we do not have hearings in the 3 months preceding or 4 months preceding the change of composition of the court. Otherwise, we would have had hearings now in November or even in December this year. But unfortunately, this year, we cannot have such hearings because of that. So coming now to the specific question which you asked, there was absolutely no suspension, and I can assure you and I can assure the audience, and I think that any misunderstanding on that should be completely dispelled, I think. Since March, what we have done is to show to the entire world that justice delayed can be justice denied. And we did not absolutely want to delay the course of justice, despite the circumstances, despite the challenges. And we also wanted to show the world that the International Court of Justice, although some scholars have always referred to it as the old lady, or a court that is, the oldest international court in the world, except, of course, a court in Central America, which was established in the first decade of the 20th century, but which did not last for a long time. It is the only international court that is this old, which has a universal aspiration and universal application of its rules. That it is an old lady, and some people thought that maybe the old lady or an old man, because I don't want to single out all the ladies, but it is the scholars who describe it as such. It's not me who is describing it as such. That it would have difficulty adapting to new technologies. We haven't had any difficulty. We were able to overcome all the challenges to our work, and we have very smoothly moved it from in-person meetings, in-person hearings, in-person deliberations to remote hearings and remote deliberations and remote meetings. And that is how we carry out our work today. Of course, the fact that we work in two official languages of the United Nations, English and French, poses a special challenge to us because, and you may have seen this with respect to the Security Council of the United Nations. The Security Council of the United Nations, while holding meetings remotely, was using only one language, English. And now that they have started meeting in person again, they are able to use all the 6 official languages of the United Nations. But they were not able to use 2 or 3 languages while meeting remotely. But we were able to overcome even that challenge after the first month. Of course, during the month of April, we were using only one language in our meetings and deliberations. But starting from the month of May, end of May of this year, in all our remote meetings, we use simultaneous interpretation. And we were able to master the technology for that by marrying together and merging 2 systems. And that is thanks to the efficiency of our registry and to the know-how of our IT people. And we are all grateful to them.
Thank you very much, President Yusuf, for that really comprehensive and rather compelling tour de force on the functioning of the court during this pandemic, and also to recognize the extremely critical role that the court is playing even during this difficult time. I must say that it augurs particularly well for a number of individuals who depend upon the strength of this institution to be able to deliver justice. And your own reflections and comments that you shared with us is immensely beneficial for that. Let me move to Justice Bandari. Justice Bandari, the fact is our world is already plagued with disruptions born during the COVID-19 pandemic, such as increasing unemployment, xenophobia, healthcare access issues, cyber security and frauds, and even domestic violence. My question to you is that, how do you imagine the international judicial landscape to evolve in a post-corona world? Some of the more fundamental assumptions that we have long held when it comes to role of judiciary in responding to injustices, have they come to be questioned during this time? Should we be expecting a reimagination of the international judicial landscape in the future to address issues that transcend what is currently as a part of its own jurisdiction?
Thank you, Mr. Rajkumar, for your question. It is indeed a very difficult task to visualize what is going to be the judicial landscape of the world. But there are some features which are likely to appear in the international judicial landscape. One is the much greater use of modern technology. because I think the courts in these difficult circumstances would use the modern technology in a big way so that justice is not denied and the court work can regularly be done by modern technology. Now, other judicial landscape which I can envisage is that now in the new treaties and convention which would be taking place, there'll be greater emphasis on equality, cooperation, and adherence to international rule of law. The other feature which I can visualize is the massive problem of unemployment all over the world would be directly or indirectly reflected in judicial landscape. Similarly, the huge problem of healthcare would also be reflected directly or indirectly in the judicial landscape. People have learned that even the most affluent and advanced countries could not provide adequate healthcare to its people. So all these questions will appear directly or indirectly in judicial landscape. After undergoing the experience of COVID-19, people will be more inclined to adhere to UN Charter providing for peaceful settlement of dispute. A new culture which has developed working from home will also have impact on judicial landscape. These are some of the things which I can visualize will happen in the judicial landscape. Thank you.
Thank you very much, Justice Bandari, for those reflections. I think your own experience of having been a judge of the Indian Supreme Court for a long time and now a judge of the International Court of Justice, in many ways gives you an opportunity to look at both those experiences as you look at the future. Let me move to Mr. Gautier. Mr. Gautier, the current crisis has created a need for more empathy in dealing with cases that judicial bodies do come into facing. Do you think it will require a change in culture, possibly to have more compassion and even emotional intelligence while treating cases? Will the current scenario that require a unique transition from the usual zero-sum mentality while managing cases, particularly in commercial disputes that go to an ethos of everyone wins, will international law also witness an increase in the average emotional quotient as an outcome of the ongoing pandemic? Or do you think that this is going to be a temporary phenomenon and pretty much business will be as usual in a post-corona world?
Well, thank you for your question. I captured the expression, the average emotional quotient, when the court is dealing with a case. I don't know whether justice is better delivered under emotion, if I may say so. I think justice is a very important notion which has to be protected, promoted, but there are some rights to be preserved when rendering justice, like a notion which was referred to by the president, the fact that justice delayed is justice denied, or the need to ensure equality among the parties. Just to respond to your direct question, the case which brought a number of questions and relating to an emotional background, a case involving genocide, for example. There was a case brought and provisional measures brought before the court before the corona. This, I don't think the two should be mixed, and that there would be some emotional increase which should be taken into account. I think if you ask my view, that those solid notions like the fact that there is equality between the parties, that you need to ensure that you need also to preserve the functioning of the court. When we were faced with this pandemic and the need to take measures, there was immediately a balance between, on the one hand, to preserve the health of judges, the court, the staff, and on the other hand, the need to deliver, to be able to deal with cases. Because that's an important matter also. And if we have moved to using electronic tools, those are tools. Those have to be implemented by human beings. We need to assess the different needs. You refer to teleworking, the possibility to organize hearings through video link. Those are tools, and they are necessary for the time being, but we need to keep in mind the human beings who are behind, and also the cost. And I refer, and I will conclude with that, when you refer to equality between parties, the use of electronic tools is also part of the equation. If you have a party which has not a good connection, not properly equipped, for example, that has to be taken into account. It's a part of the problem, it's a part of the solution too, but it has to be handled with care. Just to tell you that it will last forever, it will be part of the future setup of an international court, I would be prudent with that. But that's
Thank you very much, Mr. Gautier, for that. And I think it was a very important perspective that you provided, because sometimes when crisis happens, we do tend to react to it, not necessarily with thoughtfulness and even looking at the full implications of it. And later we probably end up thinking that maybe that was not the best way to respond. So I appreciate your own reflections on that. President Youssef, let me move on to you. This question is a very important question from the standpoint of more theoretical foundations of law itself. Now, to what extent do you think an international tribunal upholding judicial values like natural justice, equity, human dignity, and propriety, etc., at a time when judicial process is being reimagined in the light of newer social conditions caused by the pandemic? And a related question that I have for you is that, how do you, let's say, navigate the challenge of different legal systems, be it civil law, common law, in the context of the justice delivery mechanism, particularly when you are indeed facing this extraordinary challenge of the global health crisis? Can you please unmute yourself, President Youssef?
So, as you know, the International Court of Justice is the principal judicial organ of the United Nations for the settlement, peaceful settlement of disputes. And this is, of course, carried out in accordance with international law. And I referred earlier to the statute of the court, which will be 100 years old this year in December 2020. And it is in the statute of the court that we find a provision which actually tells us what international law is and where should we find it. And It is that provision that has guided since the 1920s scholars, students, judicial institutions, not only ours at the international level, but also domestic judicial institutions and other international courts that have since been created. It is this provision that has guided them and inspired them and informed them on where to find international law, and has actually circumscribed for them the sources of international law. And therefore, we still apply those sources of international law, which are identified in the statute of the International Court of Justice. We do not move away from that. Of course, the court being the organ which enforces and which implements the rule of law at the international level, because you can't have a rule of law at the international level without a court of law, in the same way that you can't have a rule of law domestically without judicial institutions. And our court was the first court that was actually established for that purpose. And it is therefore the guardian of the rule of law at the international level. And we have to see to it that the rule of law is correctly applied. And that is irrespective of the methods which are used for the hearings of the court, for the sittings of the court, and for the delivery of judgments of the court. Whether those methods are in-person methods or whether they are hybrid methods, as we are doing now, in any case, we will not use, as I said earlier, completely virtual format, especially for sittings of the court. We would not use a completely virtual format because the judges of the court cannot appear to the public and to the world the way we are appearing now in our business suits. You know, the judges of the court have to appear to the world as judges of the International Court of Justice and dress it and prepare it and looking like judges of the International Court of Justice. So that's why we adopted the hybrid format in which the majority of the court sits at the Great Hall of Justice in The Hague. But with respect to the law itself, and with respect to the rules which are applied to cases brought before the court, nothing has changed. We continue applying the same rules, and we continue developing the law through the interpretation of the law and application of the law by the International Court of Justice, because it is the court that in the last 100 years has substantially contributed, as you know, to the progressive development of international law. And if that progressive development was codified through codification conferences, most of that codification was inspired or based on the jurisprudence of the International Court of Justice. And I believe that today, the trust and confidence that the International Court of Justice is enjoying at the international level among the member states of the United Nations, because in the last 20 years, the court has dealt and has received more cases in the last 20 years than in its previous 55 years of existence since 1946. So that shows you the increased trust, the increased confidence that member states have in the court. And that confidence and trust has actually been generated and is a product of the quality of the judicial work done by the International Court of Justice. It is the quality of the jurisprudence and the quality of the work that gives confidence and trust to the member states. And that will not absolutely change because of the methods of work that we are adopting now. And that is the reason why we have to make sure that those methods of work are methods of work that are still suitable for the International Court of Justice. And I hope that you will forgive me for repeating this several times, but I have to insist on that aspect because we have a unique institution and we don't want that unique institution to change because of the methods of work that we have adopted for the because of the challenges that have been posed by the COVID-19. Those methods of work are meant to serve us, and we are not going to serve them, and therefore change our work and our the way we apply the rules because of them. We will continue being the International Court of Justice.
Thank you very much, President Youssef. I think you were very candid in mentioning about the vision and indeed the important institutional responsibility on the basis of ICJ as an institution is functioning. Let me move to Justice Bandari. Building on what Justice Youssef said, now I started off when I introduced you, I mentioned about the fact that you had a very illustrious career in India as a judge in the highest court and then to the International Court of Justice. If I may indulge you, what do you think are the possible, let's say, unique attributes and learnings that you as a judge of the ICJ has obtained now that you think is going to be immensely useful for a judge in more domestic and national settings? What are the possible unique learnings that the ICJ as an institution can provide for a judge like you, who in turn can, let's say, share that to judges who work in the national context?
Thank you, Mr. Rajkumar. The most important thing which I would like to share with my judges, colleagues in India and elsewhere is the management of the case. Because the courts, when a new matter is taken up, call the parties, fix the schedule of the case, and every step of the case is decided, and we adhere to this strictly. And for example, if 4 weeks time is given to us for writing opinion, or 3 weeks is given, if 3 weeks means 3 weeks, not even a day is extended for whatever reason. So now I have seen in last 8 years of my experience that whatever schedule is fixed, that is strictly adhered to by the court, by the members of the court, and including the date of the judgment, and we have never defaulted in it. This is the most important thing which I would like to tell all my erstwhile colleagues and the sitting judges at all levels in India and abroad, that this kind of case management which is done is absolutely necessary in other countries, because now, for example, giving reference to India, no one knows when the case is going to be concluded, because adjournment have become the rule of the day. Now the parties suffer quite a bit because the court management is not there. So that is the one aspect I think we can learn from International Court of Justice and can apply to Indian courts and other courts strictly. The other aspect is it gives you a broader outlook that ultimate goal in every case is to ensure that international peace is not disturbed. Now, whenever we decide the case, the paramount consideration is that how we can ensure that peace is not disturbed or peace can be established. You visualize the case and you conduct the case from that perspective. And while during the pendency of the matter, if the parties want to settle the matter, we try to accommodate them, give them time. And there have been cases that for years of the, matters were given to ensure that parties amicably settle the matter and the peace is restored in the respective countries. So you have a very broad perspective when you decide the case that ultimately how we can ensure establishment of the peace in the world, and wherever the peace has been disturbed, how it can be restored. Thank you.
Thank you very much, Justice Bandari, for that response. This question is to Mr. Gautier. Mr. Gautier, we did talk about the virtual hearings, possibly in the national settings, but ICJ, of course, has adopted its own set of rules and regulations. Now, my question to you is that, do you see some of these changes that have been adopted during the pandemic become part of the routine proceedings of the court in the future, especially given the amendments to Rule 59 and 94 of the Rules of Court? Is virtual courtroom, whatever mechanisms that have been adopted, are they seen to be a temporary response, or potentially they could become the future of justice delivery mechanism?
Yeah, thank you, Professor Rajkumar, for your question. If I would answer your question with one word, I would say option. It would be an option, a further option, and that is included in the rules now. But it doesn't mean that it should be a permanent feature. It's an additional option in order to keep in mind the efficient functioning and to ensure the efficient functioning of the court. And it's, as it was already mentioned, there are some basic principles when it comes to managing justice, consent-based, equality among the parties, to deliver within a timely process. And there are different methods, and always the same question is how to adjust those methods in order to comply with those principles. But those principles should remain, and the methods are fluctuant. You need to adjust, to adapt, but keeping in mind the need to deliver justice and to keep the mission of the court as a live institution. And we should not panic, because when there is such a pandemic, there is a tendency to hurry towards a certain solution or to take fast decisions. Actually, under panic, under fear, the decisions are not well reasoned. You need to consider the different alternatives and also the costs. I mean, the use of IT equipment has some cost element, and there is a moderate budget of the court. So we need to act in a reasonable manner when it concerns the managing of the finance of the court. But you need to balance all those elements and to go for the best option in the current circumstances. I would repeat, it's an option.
Thank you very much, Mr. Gautier, and thank you for being forthcoming to think about the future in that sense. Now, we are, of course, coming to the end of this fascinating program, but I promised to our audience that we'll take up a few questions. So we have got a few questions. So I'm going to get those questions to our distinguished jurists here. So let me begin with the question for our president of the ICJ. This is a question from one of our students, Ankit Malhotra, and he asked the question, will the crisis create a stronger trust on international rule of law and a stricter adherence to international guidelines, or will it lead to isolationism and a lack of faith on international organizations? It was a tough one, but let me request President Youssef to attempt to answer the question.
Well, I think it is too early to predict anything. We have been living with this in these exceptional circumstances now for about 6 months. And I think that we have not completely given up on what existed before that. We hope that the normal conditions or normalcy will be reestablished soon. If you ask me, I will tell you, if in-person meetings of the court were possible tomorrow and we were all able to come together again, I would prefer that 100% to the hybrid hearings and hybrid deliberations and meetings which we conduct now. And I would love to see the world go back to that normalcy, and all of us actually live our lives in a normal way. There's no doubt that the COVID-19 has disrupted all aspects of our life, all aspects of our work also. But I doubted that it will really create conditions which are totally different from what we were used to. We may have to adapt our working methods to this kind of exceptional circumstances, and therefore our capacity to adapt to surprises, to health and security also, because I think one has always also to think about security in this world, to health and security emergencies. Our capacity to adapt to health and security emergencies will increase. And that's not a bad thing, because I think that we will be confronted in the future also with such emergencies. And if we can already equip ourselves, and especially, for example, as far as judicial institutions, international organizations, etc., are concerned, if we can equip and prepare ourselves for such emergencies, I think it will help us a lot. We were all caught by surprise this time. Next time, we should not be caught by surprise. And I think we should be ready for any eventuality.
Oh, thank you very much, President Youssef, for that response. Let me move to Justice Bhandari. Justice Bhandari, there's a question from Swaroop Prasad. This question is about the technological infrastructure that can, help the better structuring of online courts. What kind of experiences that you can share from your own ICJ work that could be relevant for Indian judiciary, that can improve the functioning of technological platforms, even technological engagement in dispute resolution mechanisms?
Thank you, Mr. Rajkumar. Now, if I understood your question correctly, it is the technological aspects of the functioning of the court. Now, as I mentioned to you, that the court adopted these modern technology to meet the extraordinary situation. Now, this shows that if the circumstances warrant, the court can evolve a system so that justice is not deferred or justice is not denied. Now, these methods are for extraordinary circumstances, but in ordinary circumstances, the technology which is applied in the ICJ is perhaps the same technology which is applied in the most modern courts of the most apex courts of the world. So there is not much difference, but the technologies which were evolved for the extraordinary circumstances would not be used in the ordinary circumstances when the court resumed normalcy. Thank you.
Well, thank you very much, Justice Bandari, for that. Now, of course, there are many more questions that are out there which I am not going to ask because we are running out of time. But I have one last question that I will have all of you answer, and we can actually begin with Mr. Gautier. This question is about, for all those people who are watching this program, those particularly law students, law professors, lawyers, judges around the world, and of course in India. What would you like to tell them as we continue to face the global pandemic? What kind of leadership role that institutions such as the ICJ is providing that they can find confidence and solace as they look around the challenges that the world community and independent institutions are facing in their own respective jurisdiction? Let me start with Mr. Gautier.
Thank you for your question. I will answer briefly. I think what, in my view, should be kept in mind is really the trust which has been placed in the International Court of Justice. As the President mentioned, it's unprecedented, the current situation where there are 15 cases on the docket. 3 months ago, that was 17. But over the past 5 years, there is really an increase in the number of cases. It shows the confidence of the member states. That is something which should be kept in mind. It's always a challenge to deal with such a number of cases at the same time. But the court, I would say, and I speak as registrar, the court is doing fine, not only if I look at the quality of the decisions, but as a registrar, I would say it's extremely cost effective as mechanism. When you see the budget of the court, which is less than 1% of the budget of the UN, it's 25 million per year, more or less. It's a very modest budget in order to deal with those cases which are brought to the court by the members of the international community. It's a success of multilateralism, and I think that should be a message which should be kept in mind. Thank you.
Thank you very much, Mr. Gautier. Justice Bandari, the same question to you as well. Can you please unmute yourself, Justice Bandari?
Thank you, Mr. Rajkumar. Now, my advice to the students and others in this respect would be that we have seen from COVID-19 and its repercussions that there has to be greater cooperation in working with the institution. All the stakeholders must cooperate in order to ensure that justice is delivered by the court. Because if court introduces modern technology which is not accepted by other stakeholders, it would be difficult for the court to function. So greater cooperation among the stakeholders is absolutely imperative. Secondly, while dealing with the cases, we should also give emphasis on alternate method of dispute resolution, arbitration, mediation, conciliation, negotiation, because ultimate object should be to resolve the dispute to the satisfaction of the party, resolve the dispute by which national and international peace can be restored or can be maintained. You must have the broader outlook in those cases. Now, large number of problems which has arisen from COVID-19, and there'll be huge litigation because demand of justice would increase. Now, there'll be some problems which have international ramification. There's some national problems. International problems are massive unemployment and healthcare. And the peculiar problem for India is the migrant laborers. Now, those cases which come before the professionals, they must deal and handle those cases with great care and compassion. Thank you.
Thank you very much, Justice Bhandari. And President Yusuf, you have the last word, after which I will request the ambassador to also give his closing remarks. And I believe he has a short question as well. President Yusuf.
Thank you. My colleagues have already, I think, answered your question. The only thing I would like to add to that is that lawyers, young lawyers, legal scholars, students should never feel powerless in the face of a pandemic or other health or security emergency. They should always feel that they can meet any challenges thrown their way. The fact that we are sometimes surprised by certain unexpected and exceptional circumstances should not discourage you. It should actually motivate you so that you can tell yourselves, we can overcome. And in the same way that the International Court of Justice, the institution always described as I said, as the old lady of justice, has met those challenges and has overcome all the obstacles that were there in order to ensure the fulfillment of its mission and of the tasks entrusted to it by the international community. I am quite sure local institutions, domestic judicial institutions, and young practicing lawyers and students can also overcome, and they can work their way through these difficult circumstances. And I can only encourage them to do that.
Thank you very much, President Yusuf, and thank you, Justice Bhandari, and thank you, Mr. Gautier, and of course, Ambassador Rajamani, for a fascinating discussion. I am grateful to the Indian Embassy in Netherlands, as well as Ambassador Venu Rajamani and all our distinguished guests for sharing your thoughts, reflections, but most importantly, for contributing through your individual inspired leadership and, of course, the inspiring contribution of the International Court of Justice as an institution to continuously ensure that people have faith in the ability of institutions such as the ICJ to deliver justice. With those words, I'm going to call Ambassador Venu Rajamani to give his closing remarks, and I believe he has a question as well.
Thank you so much, Dr. Rajkumar, for very ably moderating this discussion. And I thank all the panelists for their very valuable contributions. I think we are grateful to you, not just for participating in this webinar and bringing your views and wisdom to the audience, but also for the very positive message you have delivered today. Surely the International Court of Justice is an old lady, but she's a lady full of energy. She's very agile, she's very dynamic, and she is vibrant with a lot of optimism about the future of international law. I think that's a very powerful message to deliver. We note what you have said very carefully. You have not skipped a beat. The International Court of Justice never suspended any hearing. It only rescheduled its discussions. So nothing has been lost from the 2020 calendar effectively. And as Mr. Gautier pointed out just now, it is one of the most cost-effective means of providing international justice, and as Judge Bhandari pointed out, a major instrument for the maintenance of peace in the world, for advancing the cause of peace for which the United Nations has been set up. Judge Yusuf, you also very eloquently pointed out, supplemented by Mr. Gautier, about how the docket of cases has steadily grown, reflecting the increasing faith of the international community in the Court of Justice as a source of redressal of their wrongs. And that you have mentioned that this reflects the quality of justice which has been collectively provided by the International Court of Justice also. While this message is well taken, I would request you, before we close this session, to just address one issue which I think has not come up in our discussions today, which is what is popularly talked about as an inability to enforce judgments. What is your experience? Are most countries accepting and implementing the judges of the court? Are there only a few outliers who do not enforce judgments? We are aware that the International Court itself has been trying to innovate and see if there are ways in which enforceability can be improved. Is truly the UN Security Council the only source of being able to enforce a judgment? How do you see the evolution of international law in terms of enforceability of the court's judgments? Judge Yusuf.
You want me to answer that? Or,
yes, please. Yeah, Judge Yusuf.
Okay. Yeah.
The last part is a question for you.
Okay. I don't think we have a problem of enforcement of our judgments. We have never had. And the only reason why we have never had it is because our jurisdiction is based on consent. And therefore, no state is dragged before the court. States that have consented to the jurisdiction of the court come before the court. And when you see a state challenging the jurisdiction of the court, that does not mean that that state does not believe in the jurisdiction of the court. It just means that it wants the court to confirm that it has jurisdiction or to say that it does not have jurisdiction. But almost all the states that come before the court come on the basis of consent. Our jurisdiction is a jurisdiction based on consent. And because states come before the court based on their own consent, then when the judgment comes out, they enforce it. Because they have not been brought before the court by force. They were not forced to appear before the court. Many people felt when Gambia brought the case against Myanmar, that Myanmar may decide not to appear. And they kept asking us questions. Do you think that Myanmar will appear? And we told them we believe that Myanmar will appear because the International Court of Justice enjoys the trust and confidence of all the member states of the United Nations, and Myanmar is a state party to the Genocide Convention. And the case was brought under the compromissory clause of the Genocide Convention. It was not a case that was pulled out of thin air. So, and you saw how Myanmar was respectful of the court, and that it was represented at the highest level of the state of Myanmar. And this has also applied to several cases that we have in which the United States, the Russian Federation, and other superpowers are involved. And people always ask themselves, will these states appear before the court? They are states that are respectful of the authority of the court. They are states that trust in the work, that have trust in the work of the court. And they are states that have never failed, actually, to appear before the court. And therefore, they always appear before the court. And in the same way, as far as enforcement is concerned, of course, theoretically, if there is a problem of enforcement by one state, there is a provision in the Charter of the United Nations which enables the Security Council of the United Nations to take the necessary measures to see to it that the judgments of the court are enforced. But that has not been actually resorted to very often, because there has never been really a problem of enforcement of the judgments of the court. There may have been one case in which a state thought that it could perhaps use the mechanism of the Security Council, but it has also not used it because I think of the bilateral relations between the states concerned. And there was also another case in which the court itself felt that the two states that were involved in the judgment may have difficulty implementing the judgment. So when the court informed the UN Secretary General at the time, Secretary General Kofi Annan, Kofi Annan brought the two states together and helped them with the establishment of a commission that would advise them on the enforcement of the judgment. And that commission helped them with the enforcement of the judgment. So there are definitely mechanisms that can be established if there is some difficulty for the two states to enforce together the judgment. But that is not a problem with which we have had to deal very often. And we hope that we will not have to deal with it also in the future. That is our hope.
And thank you very much for that very lucid explanation. Dr. Raj, do we?
All right. Well, I would like to now, propose a vote of thanks to all of you. It's really such a pleasure to have this interactive session. I'm grateful to President Yusuf, Justice Bandari, and Mr. Philip Gautier, and of course, Ambassador Rajamani. I'm also grateful to the staff at the embassy, Indian Embassy in Netherlands, as well as my own colleagues, Dr. Srijit, and others at OP Jindal Global University and Jindal Global Law School for helping us put together this, this fascinating webinar. Thank you very much.
Let me also say thank you again to Professor Rajkumar and to Ambassador Rajamani, both of you really, for organizing this webinar. And it has been more than a pleasure for us to be with you and to have this dialogue with you. Thank you a lot.
Thanks.
Thanks.